And one of the things that I hope we walk away with at the end here is, both for the sake of the Palestinians and the Israelis, they have got to turn around. If they don't turn around, Israel is going to make everyone in the world hate them. And I don't want that for anyone. It's a terrible idea. Please stop.
On the contrary, we've had a reprehensible moral equivalence being drawn between the two sides to the conflict, specifically in Gaza. One, an internationally prescribed terrorist organization, Hamas, that carried out those atrocities on the 7th of October and subsequently, and still hold over 100 hostages over a year later. And the other, the only democracy in the Middle East, and the IDF, an army that sets itself apart from every other in the history of warfare with its application of international humanitarian law. And what's extremely concerning about that moral equivalence is that it is ultimately at the center of all of the misinformation which we have just heard and which is propagated in particular for the last 13 months, and which has been the cause of a surge in anti-Semitism, the like of which hasn't been seen since the Second World War. A surge in anti-Semitism which has turned violent across Europe only in the last month. Now, it's interesting that my opponent has referred to his previous errors with respect to the Armenian genocide. In fact, he has said my mistake at the time was confusing myself for a scholar of history, which I certainly am not. I'm afraid he's also proven this evening that he is certainly no scholar of law. And when we talk about the International Criminal Court, I hope to come on to some law. But first, this reprehensible canard of genocide, which has been mentioned again this evening, the modern blood libel, which, like ethnic cleansing, apartheid, colonialism, turns international law on its head and blames the real victims of these crimes for the crimes that were perpetrated against them. I don't just mean the victims of genocide and the Holocaust, which gave rise to the term, coined by Raphael Lemkin to provide a legal lexicon to being perpetrated against the Jews, exterminating them for being Jews. I also mean the acts of genocide perpetrated by Hamas, Palestinian and Islamic Jihad, and other Palestinian terrorists on the 7th of October. The idea that anyone with an ounce of knowledge of international law would approach these issues on the effects-based analysis that we have heard so far demonstrates a total lack of knowledge, indeed ignorance, as to how international humanitarian law works, which is based on intent and not effects. And then to compound that pseudo-analysis by reference to Hamas figures, an internationally prescribed terrorist organization, figures that have been parroted, unfortunately, by international media and that are contributing to the perpetuation of this conflict. Because the reason what we have heard is so problematic is that it is playing into the hands of Hamas, whose only aim currently is to survive, and their mechanism of doing so is with mouthpieces that promote their false numbers, that promote the false information about Israel's approach and attitude to international humanitarian law, and that promote falsehoods about the current situation. We only need to hear what Gazans themselves have to say. And Ohad Hemo from Channel 12 in Israel went into Gaza only a couple of days ago. I wrote down a few of the quotes of those he interviewed. "May God take revenge on those who uprooted us and killed us in our own homes. Hamas. Hamas has wounded us and killed us. They are responsible for all the destruction. All the destruction is on them. May God settle the score with Hamas. Take revenge on Hamas. They destroyed our lives." Both Israeli and Palestinian lives destroyed by Hamas and encouraged by the falsehoods and the rhetoric that we have already heard this evening. Now, the International Criminal Court, established by the Rome Statute in 1998, was charged with bringing perpetrators of mass atrocities to justice. It has an abysmal record, ladies and gentlemen. In 2012, it was resoundingly criticised for spending nearly $1 billion and taking 10 years to deliver its first conviction. And matters have worsened further still. In 2020, there was an independent expert review of the court, and that review spoke of a workplace culture characterised by bullying and a climate of extreme fear created by the ICC's own leadership. It's resoundingly criticised also for focusing almost exclusively on African defendants and for the pitiful number of successful prosecutions that it has been able to bring. So what better means of rehabilitating oneself, of cleansing oneself in the public eye, than going after the world's punching bag, the only Jewish state? Now, the anti-Israel agenda at the ICC is not new. Even at the drafting of the statute, with the insertion of Article 82B8, a crime, supposedly, that was drafted especially to seek to criminalise the presence of Jews in Judea and Samaria, in carrying the wording of Article 49.6 over from the Fourth Geneva Convention. The drafters accepted the insertion of additional words indirectly or directly. The only state to be explicitly targeted with pseudo-international law being woven into the Rome Statute was Israel, and by all accounts it was a key reason that neither the United States nor Israel decided to join the court. What an indictment of this political institution. Now, what is critical is jurisdiction. Jurisdiction is what distinguishes a legal institution from a political institution. It is the question that gives a court its legitimacy. And when we come to the first ruling that is relevant to a discussion of Israel at the ICC, this is Pre-Trial Chamber 1 and the decision in 2021, which facilitated the previous prosecutor, Fatou Bensouda, to open an investigation supposedly against these alleged Israeli crimes. We see an absolute abrogation of the court's responsibility to apply international law, a majority decision that was heavily criticised by the presiding judge, Judge Kovacs, in his 163-page dissent. He said, "I find neither the majority's approach nor its reasoning appropriate in answering the question before the chamber, and in my view, they have no legal basis in the Rome Statute, and even less so in public international law." I mean, in judge speak, that's as bad as it gets. The ignoring of applicable international law, the use of political instruments by that majority decision, UN resolutions included, to justify its position, and riding roughshod over the question of jurisdiction, all of which were resoundingly criticised by member states, including the Czech Republic, Austria, Australia, Hungary, Germany, Brazil, Uganda, and numerous experts in international law, some of whom are with us this evening. So the jurisdiction of the court, let's be clear about this, can only be delegated to it by member states. Israel is not a party to the ICC, and the state of Palestine does not exist. It is unable to comply with the basic requirements of the Montevideo Convention criteria, including a permanent defined territory, effective government, capacity to enter international relations. But perhaps most astonishingly, the pre-trial chamber in 2021 refused even to consider the application of applicable law, including the Oslo Accords, which under Article 17(2)(c) and Annex 4, Article 1(2), expressly provide that Israel has sole criminal jurisdiction. So the only way that the supposed accession by the Palestinian Authority to the ICC could possibly have even been argued to take place is undermined by the very document, the very international agreement that created the Palestinian Authority in the first place. The list of legal flaws in the pre-trial chamber's decision is extensive, but it pales to insignificance next to the application for arrest warrants, which we had on the 20th of May this year, which is done on the absence of jurisdiction, without reference to the principle of complementarity, the founding principle of the court, which means that its jurisdiction is only exercised as a complement to national jurisdiction, not as a substitute and based on a series of false allegations. My organisation, UK Lawyers for Israel, has proven that every phrase of every sentence contained in the prosecutor's public statement explaining his grounds for the application for warrants is false. This is an indictment, ladies and gentlemen, on the International Criminal Court, which is enforcing all of the falsehoods that we heard without legal basis to them already this evening, and that is an indictment on international law generally. It should worry every single individual who cares about the rule of law, because with what starts with Israel, I promise will be unlikely to end with the Jewish state.